Welcome to the Beacon Way podcast, hosted by award-winning executive team of Beacon Media and Marketing. With over 3 decades of experience, Adrienne, Jennifer, and Ken give you an insider's view of what's working, what's not, and what's on the horizon for digital marketing. Grow your business today with the Beacon Way podcast.
Hello, and welcome back to another episode of the Beacon Way podcast. We're excited to have you join us today. We've got a great guest. His name is Mitch Beinhaker. Is that right?
Beinhaker, you got it. Yeah,
awesome.
Right on.
All right. Mitch is in business law and estate planning. He's provided his legal services to single-family businesses as well as multifamily businesses. And you've been in this field for at least 30 years.
I'm pushing on
right?
33 years of practice.
Exciting.
Yeah.
And primarily out of New Jersey, but
I'm admitted in New York. I do some federal tax planning, but yeah, mostly New Jersey.
Okay. Fantastic. Yeah. And you specialize primarily in business owners, entrepreneurs, executives?
Yeah, mostly business owners. Even a significant portion of my estate work and real estate work is usually for business owners. Yeah.
Wonderful. Wonderful. Yeah. So we're going to dig into some of the legal interesting side of being an entrepreneur.
It's not boring. Don't tune out.
Yeah. I know so many people avoid it. Oftentimes the legal side, the money side, the estate planning side.
Right.
But I think that is one of the powerful things, at least from my standpoint, of being a business owner, is being able to have the flexibility to structure things like that the way that you want and be able to build generational wealth and pass that on. But I think a lot of people avoid it, but to me, it's really exciting and a cool opportunity.
Yeah. I don't know where you want me to start, but I think the biggest problem is, and I didn't even mention to you off camera, so I wrote a book about it even. We can talk about that a little bit, but is that it is kind of boring and, to put everything in writing and to go through the whole process of writing contracts. But first of all, it doesn't have to be boring, because when you get through it, you can really lay out how you want your business to operate with your partner, with other people, how you deal with customers. And also when it comes down to disputes, misunderstandings, discrepancies, if it's not in writing, first of all, myself as an attorney, I have a lot of trouble helping clients when they don't have things in writing and they're cobbling things together between text messages and all kinds of stuff, right? That doesn't really make a contract. Yeah. And nor do judges they have a terrible time with this kind of stuff. And it just ends up being like a judge would just split up your business, just separate it, and you're screwed. So a lot of that stuff becomes really important, when you move forward with your business, as you get more into, past the startup stage. You're now making money. You're doing this for real. You have a partner. You shake on things. You have some misunderstandings, and then what do? And it becomes problematic. So it is important. I also think that we tend to remember things to our benefit, not to our detriment. So as much as we want to think we're objective, our minds seem to play tricks on us, right? We're not perfect. We don't store things like methodically in like a little file cabinet. It's just a mess, right? I used to say it's like a box with sticky notes and the notes stuck all over the place. So you're
pretty sure that's how my brain looks.
You and I, right? You're sure that on August 1st we had this podcast and we talked about this, and you're like, I was on vacation in the Caribbean in August. I wasn't talking to you then. You're like, you weren't, and you get a lot of that stuff. So if it's in writing, at least you can go back and have some confidence that I guess that's what we talked about because we wrote it down then.
Yeah.
So it becomes really important. Yeah.
Would you advise for a company starting, I think it's funny that you would say the handshake thing and whatnot. That's my co-founder who's since exited the company, but 13 years ago when we merged our two companies, there was a lot of handshake stuff. And we did have to go back later and go, okay, it was a really fast. We kind of threw together the first digital marketing agency in Alaska. And even that was so raw 13 years ago. It was kind of like, we don't even know what a digital agency looks like. But it was a very interesting process to transition from, handshake to now putting it in writing. What are some of the common things that you see in those transitions that you're like, man, if you had just done this first, it would have been a lot easier now. Like, what are some of those common things that you run into?
Well, I mean, I think that people don't really understand what it means when it comes to like, I'll call it corporate governance when it comes to managing your company. So the two common entities you see with small businesses are either LLCs or S corporations, right? So you have a corporation that makes an S election for tax purposes, and that's just really just makes it a flow through entity. And by the way, people listening, in most states, you can also make those elections for an LLC. So you can have an LLC that's treated as an S corp, and then the S corp rules apply. It doesn't convert or anything like that. So, and the good thing about that is if your CPA tells you 2 years in, you really need to be an S corp, you can make that election and you're good. The good thing about an LLC is that, and sometimes it's bad, is that you make the rules. There are very little statutory, rules and regulations for an LLC. It's guided by its operating agreement. So if you don't have a written, signed operating agreement that addresses what you do, Adrienne, with the company, what I do with the company, what we're authorized, what we have to decide on together, how do we break ties, what happens if we do want to walk away? What happens if one of us dies, becomes disabled, whatever, that becomes problematic. If it's a corp, you're talking bylaws, right? Which are more like generic about who the officers are, and then like minutes and resolutions and things we decide, and which is a good way to, that's a good practice even for LLCs, but it's a little bit different, but it does the same effect.
Okay.
Then as you get, and so that's like the start. And I'm not saying like from day one, you should be doing that. Maybe you should be, but a lot of times you're starting up, you got a lot of costs, and depending on the part of the country you're in, it could run you, let's say on the low side, 1,500, the high side, 4,500, 5,500 for a operating agreement startup package type of thing, depending on where you are. In my area, New Jersey, it's probably more like 3,500, something like that.
Okay.
But maybe, I don't know, within the first year, now that this is serious and you're doing this stuff and you've made notes and you wrote things, put it in writing and sign it and do that kind of stuff. You may need it also for like banking purposes or for you need to borrow money or, you're bringing in investors. So then you're going to need that stuff anyway. So that's the first thing. And you might even want one if it's just you. I mean, there's a lot of reasons to have a written operating agreement, a solo operating agreement. And then as you get more into it, then you want to do something called a buy-sell agreement, a buyout agreement. Okay, what happens if one of us wants to walk away, which becomes a problem? One day, I had a lot of this during pandemic. People would come to work and you're like, Mitch, I've been evaluating my life and everything that's been happening in the world, and I am just not doing this again anymore. I'm walking away, so buy me out. And you're like, buy me out? What are you talking about? We just started this business 3 years ago. I don't have the money to buy you out. Right. So you have to kind of put that down in writing and how you're going to deal with it. And maybe it's time sensitive, you less to buy out now and 5-10 years more. I don't know. But right. So you address that. You want to walk away. You also address the issues of what I call involuntary transfers, which is you're being sued or you're getting divorced or whatever it is. Somebody's trying to grab your share of the company, and how is that dealt with? Right. So that's involuntary transfers. The third thing would be if someone dies prematurely, how do you deal with their estate? What happens? Do you end up in business with their spouse or no? Or do you have to buy them out? Can you, maybe you're young enough and healthy enough to insure with life insurance, which is very common, but not always an option. And the fourth thing would be disability. Somebody becomes disabled and they're just dragging down the business and they're trying to come back to work and they can't. And you're like, listen, Mitch, I know you're giving it your all, but you just got to deal with your health issues and I got to move on and buy you out and you get some money. And then, and how you're going to do that, because can't always insure those things. There is disability insurance, but sometimes hard to get. It's based on the industry. Right. It's hard, especially in younger businesses. It's harder to get. So those are like the four things. So you'd have your operating agreement, your operating documents, and then as you get going, a buyout agreement in place for the things. And then, you review that every once in a while. And, maybe it becomes the operating agreement's kind of taken from your business plan, which I know people listening, probably a lot of them don't even have written business plans, but they should. And those becomes like a business plan should grow into like guides for, marketing, guides for finance, guides for how do you run the company, operations, employees, things like that over time. If you're diligent with your paperwork. Yeah.
You said that's a magic phrase there. Diligent with your paperwork.
Well, the best entrepreneurs I've met and have had on my show who are continually successful. I mean, they're very, they know what they need to do. They get it done. It doesn't get in the way of running the company, but they know that that's what they have to do and just have it put aside and have it taken care of. And eventually, if you're successful enough, you have an attorney like me. on monthly retainer, and it's my job to make sure that your governance is good and all the things are happening, contracts look good with clients and things like that. So, but that was a long-winded answer to your question, I think.
It was a great answer, though. At what point do you see where it becomes really beneficial? Like you just mentioned, there's typically a tipping point, if you will, where now it makes sense for a company to have an attorney like you on retainer. And I remember when we hit this, and it was such a weight off my shoulders because it was, as the primary, shareholder and the CEO and all of those kinds of things, it always felt to me to maintain all of that. And I know there was, a tremendous amount of stress because I'm a good paperwork person, but I am not an attorney by any means, you know, and
I've been doing this 33 years. I've done hundreds of thousands of transactions. Yeah.
Right. So like if somebody's in business and they've been in business for a while and they're kind of going, what's a good measuring milestone for when they should come sit down and talk with somebody like you? If you were going to kind of name a milestone, what would you say that might be?
I don't know if it's time-based. I find that when I work with newer businesses, if I get them started on one-off projects, maybe some hourly work, but if they're calling me every month, 2, 3, 4 times a month because there's issues coming up with customers, with vendors, with the state, dealing with towns, trying to think what other things they do, partner issues.
Right.
I usually recommend to them that they at least go on, like I have a basic retainer of it's $8.99 a month. And what it does is it covers pretty much your time if you're emailing me, answering me basic questions. But if I have to do work, that would be discounted, right? So then if you move up to the next tier, which is like, I don't know, instead of $8.99, it's $18.99. They get a bigger discount, more hours. So they're buying hours at a discount, basically.
Gotcha.
And then it's not necessarily cheaper. I'm not suggesting that it's cheaper, but what I'm saying is that I now have the responsibility of being on top of your business. If you just call me and say I need an operating agreement, I'm not going to make sure all your filings, I'll do part of it, but it's really on you. So if you want to get that off your desk and you want to hire me without getting a full-time general counsel that you probably can't afford for $150,000, $200,000, $250,000 a year, that's a good way to do it. So I would say once you have, maybe you have several employees, right? So you have employment law issues with different states. Maybe you have a virtual business. So you have some people that work for you in California, which is very stringent, and New Jersey and Florida, and you have things going on. That's when you should have a good general counsel. I'm using the word general because it covers a lot of bases. So if I have an employment issue for you that's complicated, I have an employment law firm that's on retainer to me because I do work for them and they do work for me, and I can get things done and answer questions. If I don't litigate, for example, but if we're getting sued or we got to sue somebody, I bring people in, I'll guide you through it. I'll stay involved. There's not more, it's my time, but there's not more charge on the other attorney, and I can kind of quarterback everything and sometimes even get questions answered without you having to pay somebody to do it. So because of professional courtesy back and forth, so it becomes a good quid pro quo. So that's what I would say to people, if they are pretty busy with on a regular basis the legal issues that are popping in and they're trying to deal with themselves, that's when they should approach whoever their general business attorney is that they've been working with in their area and say, hey, do you have like a monthly retainer program where we can pay you $500, $1,000 a month to be available to us to do work, and then if there's other work to be done, you can discount the hourly or discount the package or whatever it is. So that's kind of the measuring stick that I use.
That's a great one. Like I said, it was I would definitely encourage all business owners that are listening that this is definitely a worthwhile investment,
and it's something to work up to. And I tell clients, listen, you're calling me a lot. Yeah, I really should move you on a retainer program because it's going to be more worth your bang for your buck, so to speak. Yeah.
And one of your specialties is that kind of commercial real estate law piece. And a lot of our listeners, being mental health practitioners, they're dealing with commercial leases and different things like that. Telehealth took off a lot during COVID, but has kind of gone back down almost to pre-COVID norms. Not entirely, but very close.
Basic stuff you do telehealth, but most of the time you want to see your doctor, right?
So most of the time, people, I feel like what we're seeing across the board is people want to come back to face-to-face.
Yeah.
There's definitely some rural areas. We do a lot of work in Alaska and places like Montana and Wyoming, and those places telehealth has stayed pretty high because there's so much of a rural population.
Yeah, so you do a lot of travel and distance.
Exactly.
So it's good for that stuff. Yeah.
It is great for that. But most of our clients, I would say, are trying to deal with renting space,
Of course.
that kind
Even the
of thing.
telehealth, they're not working from their home. They're still taking
Right.
space, right? Yeah.
Exactly.
Yeah.
So what are some of the most kind of misunderstood aspects of like negotiating a commercial lease that you're seeing, or areas that kind of pop up? You're like, yeah, watch out for this kind of thing
Yeah.
in that space as you're trying to negotiate the legal side of it.
Yeah. A lot of times we may be buying a business, assuming a lease, we may be assigning a lease because we're selling a business, or I get a lot of calls for just reviewing a lease. They're looking at space. So
Okay.
some of the things that I see that are lacking, first of all, you got to remember that the lease is usually provided by the landlord, right? They have their standard lease and they want to do it. And it's going to be, in most cases, very landlord favorable. So signing a lease without having an attorney review it and make changes and comments back and forth, is really a dangerous way to lease space. I know people are busy and they're running their practices. Oh, fine, I trust this guy. But this guy may not be the guy you're dealing with later on. It may be his wife, it may be his cousin, it may be somebody else. He may sell the building and then your lease gets assigned to the new owner, those types of things. So first of all, it depends on how the lease is structured, but if it's what we call a triple net lease, where you are responsible for all the common area maintenance charges or a portion of them, and you get a bill from the landlord every month, you definitely want to have a provision, and I don't see them in a lot of landlord written leases, that allow you to, doesn't mean you can't pay the bill, but it allows you to question the bill, ask for, backup, and say, things like, I don't know, if you're in the north, you're like, well, we didn't have any snow this year. Why am I getting a snow bill for, things like that? And there's things like that happen. So I've had a lot of situations where, and like I said, I don't litigate, but I have to take them to a litigator, and now we're dealing with the landlord and they're suing back and forth. If it's not in writing, it's not in the lease, they're not going to have a lot of teeth when it comes to going to court. So that's one of the things I see. I also see you may want to focus on things like the assignability of the lease, because especially nowadays, if you're a mental health practitioner, there's a lot of roll-ups and you get bought by these practices. And if the landlord has a lot of control over what you do, he or she may be able to block the purchase of the business, or maybe you just want to sell it to another small business owner. And I just reviewed a lease where the criteria for the new owner, so the lease basically said, listen, you can't assign the lease unless we give you permission. But if you sell the business, you don't need our permission as long as the new guy meets this criteria, right? And there were like net worth criteria and liquid asset criteria, none of which my client who's renting the space met.
Yeah.
Like he didn't even meet the criteria. So yes. Now it's a big landlord. So I have a feeling like the lease was standard and they didn't really look at it. But when I would go back to the attorney, I was like, that is absurd. You can't. So he said, but they want it in there. So we proposed like much lower realistic numbers, like if in this part of the country where I am, $1 million in net worth is probably your house. So that's not a big deal, but they wanted like 5 million or 10 million. It was ridiculous. Wow. So you got to watch out for things like that. If you want to sell the business, no matter what kind of business owner you are, can the landlord block that? I had one that was a spa. It's in the health and wellness, right? Therapeutic massage and things like that. She had a buyer, and the buyer, I thought, was financially stable, but the landlord didn't think so. So even with extra security deposit, he blocked it because her lease, I didn't know her then. Her lease just said landlord can withhold approval for any reason. And he killed it at the last minute. So
that's brutal.
Yeah. And she ended up shutting down the salon. So I think she didn't sell it. So so you get a lot of that stuff when it comes to commercial leasing. Those are the kind of things that I see. Insurance. I also see, I don't like, and sometimes landlords will agree to this, sometimes they won't. I don't like landlords passing on the cost of like capital improvements, because if they're putting a new roof on the building, it inures to the benefit of the property owner, not to my client. So he or she's okay. But landlords like you to pay for that. They want you to pay for everything. They want you to pay for your insurance. They want you to pay for their insurance. My feeling is you shouldn't be paying for their insurance. You're paying for your insurance. That's why it's there. So you got to look at a lot of that stuff and push back a little bit and see what the landlord, will agree to. I've had LOIs come in, letters of intent, where it said, it's going to be whatever, I don't know, $15 a square foot. no extra costs. And then you get the lease back. It's got this other, and they say, well, I didn't mean that. And you're like, well, no extra cost whatsoever means nothing.
No extra cost.
Like forever and ever, right? The and ever is not really like something you need to include because forever kind of covers it. So then, then you get some pushback in the land, but landlords want to rent space. So they're like, all right, fine, we'll adjust this and we'll do that, whatever.
Yeah.
But, once you're kind of in writing, signed, they're not going to change it later on.
Mm-hmm.
There's also fees in there for transfer. I've seen fees for you sell the business, but you're still going to remain liable. And you both have to put a security deposit down. This is common. And I like to negotiate those out because if you're selling the business, you want to be liable for I've had businesses sold, client couldn't get out of the lease for, let's say we negotiated it down to a year or two. One of this I remember was during pandemic. So we negotiated it down to like a year or two, but the buyer went under within that period of time. So then the landlord was suing my guy, his ex-partner who was still, part of this lease, the new buyer. It was a mess. They were suing each other. Wow. We finally eventually settled it. But, there was a lot, it was a lot of legal fees involved and it was a mess.
Right.
Yeah. So you really want to read what you sign and you really want to say, does that make sense? Will that work if this happens? Why should I be liable? How do I get out of this thing? So, and commercial leases, unlike tenancy leases, landlords don't always have the obligation to what I call mitigate their damages, which I like to include in there too. So,
that's a good point.
Go out and get a new tenant. If you get a new tenant, I should get off the hook. You got a new tenant, guy qualifies, whatever, right? A lot of these leases hold you liable too, so they can just sit on the space and go rent their other buildings and keep collecting rent from you. So
it's definitely a quirky world, that side of it.
And sometimes the landlords have the upper hand, but that doesn't mean you should be, just because you think is the greatest space you've ever found, it's going to be perfect for your business, that you should be signing your life away, because ultimately it just puts more strain on your business and you want to be successful. So
yeah, absolutely. I know I think that one of the things I've learned over the years too is I found that it seems like landlords like to leave certain things vague and open to interpretation.
Very much so. Yeah.
Yes, I've run into a few of those and had to learn the hard way over the years of like, no, the blinds are not considered, the blinds were there when we moved in. They're part of the property. Yes, you will replace those.
Correct.
Quirky things like that.
Well, a lot of the leases say that the landlord will get the property ready as a, in a what they use the term plain vanilla box, but nobody has a standard definition of what the heck that is.
Right.
So especially if you're a healthcare professional, if you're a doctor moving into a space, you got to fit up the place with a lot of, so what are they doing? They're doing sheetrock paint, electrical, what's the, you got to really be detailed about that because it will definitely lead to an argument. And at the end of the day, what are you going to do? You got to get open. You're going to have to spend the money and you're going to be stuck. And usually when those fixtures, anything you install that becomes part of the building becomes property of the landlord. You can't rip it out and take it with you because you're just going to cause damage and you can't use the toilets in a new place and whatever.
Right.
But you got to know that's what you walk away from. That's the deal. Options too. I get options to purchase, options to renew. Make sure that you mark your calendar and you know when you're supposed to exercise those options. I had a guy lose a $2 million purchase option on a property that had appreciated to $13 million because of changes in the marketplace. And because of bad advice or whatever from a former attorney, the guy screwed it up for him. He wasn't able to buy the property because the client was like, the owner was like, I'm not selling it for $2 million. You didn't do this, and this. Good luck, and and it really hurt his business. He had an opportunity to really keep the business there and buy the space. And I don't know where he is now, but that's, So you got to make sure you follow those rules. The courts will hold you to what you signed. You're all adults. It's commercial space, B2B. Good luck. Yeah.
You signed it. You agreed to it. You didn't have to sign it. So
correct.
Yeah, correct. Exactly.
I like non-disparagement clauses too. So if you have a big problem with the landlord and you hate each other and they're not posting things online for each other, I literally had a settlement agreement once. I think it was between a landlord. I forget who it was, a landlord or something. And the client left me a message saying, I was reading this lease. What do you mean I can't post anything online about these people? And I was trying to explain to him, well, that's what a settlement is. I don't think I even put it in there, but I didn't want them to post anything bad about him. So it's a quid pro quo thing. It was so funny. I was like, I couldn't help but laugh. I'm like, that's kind of what settlement is. You don't go out and say bad things about each other after you come to an agreement.
Right. That's part of the purpose of a settlement for sure.
Exactly.
Well, and I've had landlords ask for references for previous landlords, which that would be helpful in that case too. If you're, you know, if you had a messy separation
Correct.
in that thing, you
Yeah.
know, you don't want them spreading.
Yeah, that's not like an employer, because you call an employer, they can only verify employment. That's it. But landlords are, all bets are off.
No, my father is a licensed professional counselor. He just retired after 30 years running a medical and counseling practice. And he ran into that where he had a lady that was doing the medical billing that got caught embezzling quite a bit of money.
Yeah.
And turns out she had been doing this all over town, and she was smart enough to keep it just under the amount that's not really worth prosecuting.
Right.
And because when people would call for references, they couldn't do anything besides verify employment.
Right.
Nobody was able to say anything.
Right.
And in fact, my dad ended up getting a call about a month after they fired her, and actually called his attorney and was like, "What can I tell them?" And they're like, "Nothing at all."
No.
You know? No. And he's just like, "This is going to happen to somebody else and I can't do anything about it."
Yeah.
And she did eventually end up getting caught because enough people got together where now it was worth it.
Yeah.
But she had quite a thing going on for a while.
No, it's no question about it. Some people really know how to game the system.
Mm-hmm. Yeah. She knew,
but that's why you should have agreements with your employees about non-solicit, non-compete, non-disclosure. Mm-hmm. You know, you get fired if you commit a felony, things like that. But you're right, you can't disclose it to future employers. You should file like a municipal complaint, so maybe there's a public record of it, and then it'll come up on a search. But you know, don't overlook background searches on employees, because the employer's not going to tell you anything. So you got to do your own due diligence. So I know it's not just looking for. Especially in the healthcare space, you know, you're talking HIPAA and all kinds of rules and stuff. You really, I've had people call me who were, nurses or PAs or whatever at practices, knowing that there's, they found out that there's some bad things going on, and the person's getting in trouble. They had nothing to do. And they're like, I don't want this to come back on me. Like, how do I handle this? Right. And then, the authorities come to talk to her. So we have to get her a lawyer and talk to the, to make sure that she's got immunity. She didn't do anything wrong, but she found out. But also, don't just turn your head to once you know about it, then it becomes a problem.
It does.
You don't know about it, that's different. But once you have knowledge that this is going on, get out and tell somebody about it who you're allowed to tell, like your lawyer, and get some legal advice. Yeah.
Because otherwise you're at the very least considered complicit.
And especially if you're a licensed professional and you have boards that you have to answer to and issues, and you can have licensing taken away and get fines and, potentially jail time. I mean, all kinds of stuff. So you definitely want to get out in front of those things right away.
Yeah, absolutely.
Yeah.
So you work with a lot of family businesses, which I love. I've been involved in multiple family businesses. So how do you kind of help families when they're looking at multi-generational things, which I think is one of the beauties of a small business, is being able to pass that business on, obviously, when you have kids that are interested in it,
exactly.
or maybe not, and still have to do it. But how do you, what are some of the main things that you advise people for as they're looking at maybe even setting it up right from the beginning? What are some of the pitfalls to avoid? What are some of the things to look for to be able to really ensure that your business can be passed down to the next generation and that sort of thing?
Yeah. I mean, some of it is difficult if the kids are young, right? Because you don't know if they're in the business yet, or even if they're young and in the business, the teenagers, and they're in their 20s.
Yeah.
But when it comes, so there's a lot of, what's the best word? Things that you should, so you should be structuring your documents kind of with that in mind when it's a family business, right? So I'll give an example. Sometimes, and I do a lot of this work for families, right? A lot of times we have, let's say the parents are in the business. Let's say it's 2 or 3 brothers, 2 or 3 sisters, and they're in the business, and now their children are in their business, and they're older, and the children kind of run the business anyway, and they're ready to kind of keep this thing going. So how do you? So a lot of times what we'll do is we will, put the parents on consulting agreements and then pass the business on to the kids and so forth. But sometimes there's a building involved, there's real estate and there's the business. So you have 2 entities, and everyone may want to do different things with the business versus the property. So the property is a passive investment, right? The building, the business pays rent to the building. So sometimes what I have happen is we have the building being passed from the kids to their kids, because it's okay. They're not, maybe in a trust though. So there's not 42 people cause I have taken over buildings where there's like literally 22 fractional shares all over the place. Yeah, it's a mess. You should see what these deeds look like. It's crazy. You got to get a title company to trace the whole thing. So that's, but I have done with standalone trusts where the wills would take, so if you die, your portion would go into the group trust and your children are one of the beneficiaries of the trust. Okay. So the income still flows to the families and the building is still managed by a trustee or the remaining partners or whatever.
Nice.
Separate from that, we would do an arrangement with the business where, the business would pass to the children or the remaining partners, depending on who's in the business, subject to change over time. I mean, it is something that you have to review because it's a dynamic situation, but there's always ways to do it and to do it from a tax efficient standpoint also. Sometimes the difference between the parents paying income on, let's say, a consulting contract and gifting the business to their kids is pretty much the same rate as if they paid capital gains and sold the business. But my client doesn't get a deduction for that. They get a deduction for payments for consulting work. And in fact, the parents are still working in the business. So it's legitimate. There's nothing not legitimate about it. But a lot of times the transactional people are all like, oh, well, you're selling the business to the kids. Let's do a sale, an agreement, and this and that. You pay him money, and then he pays tax on it. And I don't want my guys to pay. Taxes are voluntary as far as I'm concerned. If you can plan your situation to minimize your taxes, you're allowed to do that legitimately.
I love
so
that. Yeah.
You get a lot. So a lot of that, there's little parts and you can kind of get to where you want to go and still be efficient about it when it comes to the different aspects. And then there's usually insurance involved. You want to insure different people and you have insurance on the parents. Should you keep that? And then it would come back to the business to help them. So, but you definitely need a management structure because you get kids that are, and then they all have different ideas of what the business should be doing. So you got to get them on the same page and kind of, yeah.
That sounds intriguing and maybe headache.
It's complicated. It gets, it does get complicated. I've had situations where we have, like 5 or 6 siblings, but only one of them's in the business. So how do you make things equal if something happens? And does the kid take the business and the parents take the other assets? But maybe the other assets aren't. Maybe the business is a significant portion of their wealth. So does the kid have to buy out the other kid? In some cases, I've had that happen where the kid said, all right, I'll buy out my siblings over time. What am I going to do?
Right.
And then I've had other situations where, like, let's say there were several siblings at the older generation level. And over time, one of them had passed away. So there was a new kid in the business and then the other two. So it gets, it gets complicated. Some of them have children, some of them don't. Where does their piece go? So you don't want to accidentally kind of knock people out of the list from a request standpoint. But at the same token, your brother may not want to be in business with your children. I don't know. It depends on how it evolves. Yeah. Those businesses have me on retainer. Those businesses need me.
I would imagine.
Those businesses I bring in fractional CFOs to work with them, or fractional CFO brings me in to, get them online and back on, because, older generations, they didn't do that kind of stuff in those days. A lot of it was handshake. A lot of it was not properly documented and they were just trying to make a living. And now the world's become a much more complicated place. So.
Yeah, I was talking with a friend of mine who took over his father's insurance business, and the father passed it on 50-50 to him and his sister.
Who wasn't in the business?
She has never been in the business and does not want to be in the business.
Right.
But she's a 50% owner, and so she does want to say. But she doesn't really, she's not participating in a day-to-day place. And she's got a family. She's doing all this stuff. And the brother's struggling with, how do I keep a relationship with my sister and have this conversation with her?
Yeah.
Because she kind of likes the status of it, but not necessarily,
probably likes the income from it too.
Right. And he's like, he loves her. Yeah. He's like, we actually have a great relationship. He's like, and I want to keep that.
Yeah.
And he's just like, what do you think? And I'm going, wow, that one, that one sounds like a minefield. I'm just like, just have to have an open, honest conversation. But that that's easy to say and a lot harder to actually do.
Yeah, I mean, look, those kind of businesses that are renewal based, residual based, become problematic when you have one child in the business and one not, and then half of it goes to the other child, and then what? So there's a difference between, okay, we're sharing in dad's book of business for 50-50. What about as I grow the company?
Right.
If you don't have anything in writing and it's just left that way, you got to give this person 50% of your income of the growth of the profits of the business, even though they're not contributing to any of its growth. So do you wall that off? I mean, all that needs to be addressed in agreements. And I've done work for families that had insurance, practices, especially the ones like property and casualty, which you could own and not have a license and things like that on like financial services and stuff.
Right.
Where, we're trying to like give the other child their due value that came from the dad, but not, if they're not participating, they shouldn't be getting income from the growth of the company. So it becomes difficult. Those kind of businesses have to really be laid out carefully.
That's a good way to I think to distinguish it though, and still be respectful to what, in this particular case, the father's intent clearly was, I worked and did all of this, and now I'm going to take care of both my kids this way. But yeah, I think that's a good distinction to make, because then, the one that's left is feeling resentful because this is now business.
Exactly. What really should happen is the business should be left to the two of them, but the operating person should have the right to buy the other person out at date of death value over time, unless there was insurance on the dad or something, right?
Right.
So therefore, you just kind of freeze that in time. The person has a note now that they're owed money at interest, and the business pays it off, and then the growth, you don't have any issues. That's the way it should be. That's the best way to do it. The fairest way to do it. I don't know if everybody thinks it's the best, but
it does seem the fairest to both parties.
I mean, if I was the other person, I'd be like, no, I want to own 50% of this business. Let my brother grow.
Right, ongoing, yeah.
Yeah, but it's not fair.
So my one of my business partners, he says, a true negotiation means that both people walk away feeling a little like,
a little pissed about it.
Yeah, a little pissed about it. He's like, you've met somewhere in the middle when both of them are kind of like, well, I got some, but I had to give some too. And I always thought that was kind of interesting of like,
I mean, it can get really hairy. Like the working brother could just shut the business down and transfer the business to a new entity.
Ooh,
because if there's nothing in writing.
Right. Yeah.
And then she could sue him and say, hey, you took the business away, and then he would say, well, I'll pay you your half of what, Right. I mean, there's moves to be made. I had a partner, actually, I was helping a lawyer deal with this. So there were partners, and one of the partners decided she wanted to move to, I don't know, let's say Europe. I mean, overseas. But she still wants to be involved in the business. So the other person's like, what are you talking about? Like, how? I mean, you're not here. Like, we can't. So she didn't want to work that way. And they were going back and forth about, and she's like, well, then I'm not going to take on the new clients, and I'm not going to do this. I'll do it in another entity. You can't do that. Well, they don't have anything in writing. But there are duties owed to your company, like as a, right? So you have those issues back and forth. And I don't know what a judge would do with that stuff. They would say, well, you owe a duty to the company, but the other person moved to, I don't know where it was, Switzerland or something.
Yeah.
How is she going to work with you from Switzerland? that wasn't contemplated in this arrangement.
Right.
So it gets to be.
Technology is interesting today because it can allow for a lot more of that stuff.
Right.
Even if it's a transfer of duties, I'll run all the medical billing. I'll run the admin like that.
Can do that, but the other person's like, but you're not in the United States. I didn't plan on that.
Right.
Well,
exactly.
I don't know what a judge would do with that. I don't know.
Yeah.
You'd end up settling is what would happen, but I don't know.
Sure.
It can get expensive.
So for people contemplating a partnership, taking on a partner or, even an investor that wants equity, when they come to you and ask like, is 50-50 better or like 51-49 better? What's your general advice on that? Is it really kind of situationally dependent or? Okay.
I don't have any general advice on that. It is problematic. If somebody's joining the business and they're buying half of the business, they're putting in equity, right? And it's a 50-50, that's fine. But what do you do if you can't decide on something? Because I always find that the non-decision person really has control, right? If you need to both agree to do something, then the person that doesn't want to agree really has the control. So you got right. So you got to figure out: are we
Yeah.
going to use our accountant as a tiebreaker, or some sort of a system?
Okay.
And passive investors are a little bit different, right? So
Sure.
I structure a lot of things where the passive investor they may be on an advisory board, they may not even have a right to vote,
Right. Okay.
So. And it depends on how many partners there are. You might have 3 working partners and 5
Sure.
investors, and maybe the main managing partner has, I don't know, 2 votes, and the 2 other partners have 1 vote each. So therefore, if you think about it, if you need 75%, then the person can't do anything alone, but they got to at least convince one of the 2 partners to do something. So it kind of becomes a little bit more of a democratic society. But 2 people, which is common, is problematic.
Yeah.
You really need to address those things up front. How are we going to deal with this? Not if, but when we disagree on something, because we will.
Right. Yeah.
It's just
I know
happen.
people tend to shy away from those conflict-filled conversations can be challenging.
But it could lead to the termination of your business.
Right.
It could lead to the dissolution of your business at very, very, very discounted values, because your company isn't worth anything if it's broken up, right?
Right.
If you don't deal with those issues ahead of time.
Right.
I've had situations, family businesses, where
Yeah.
the business got left to the 2 brothers, and maybe they're both in the business, but one of the brothers really becomes the president, takes off, really grows the business. The other brother's basically like working, but not really working. He comes and goes, but he's still entitled to 50% of the profits. There's nothing in writing. And I get referred to the president and says, I really need to change this and what do I say to my brother? I go, if I was your brother, I wouldn't do anything.
Right.
How do you convince him to give up, what his 50% because he's not doing his job?
Right.
You can fire him, but he owns half the business.
Yeah.
So
then he's even less involved and still entitled to
50% of the profits. Then if you're playing around with those, he had a right to sue you, and it becomes a mess. So, but it was not, it was a little business when the dad had it. He leave this little business to 2 sons. One of the sons, literally, I think this business was like, let's say a $10 million business. That was a $100 million business.
Wow.
And, and this guy just let it go because he didn't want to deal with it. And I don't know what happened to him. He was a colleague he was a client of a colleague of mine, but it was not a good situation. No.
Yeah. What are some things that you've seen as far as the tiebreaker part of things? Like
that works?
Yeah. Ideally, yes.
That's a good question. I don't know of any situations I've had where there were just 2 partners and they couldn't agree on something and there was really a good result. There was, like you said, there was a settled result. Neither party was really happy. Maybe they broke up. Maybe they stayed together. I find, though, that if you can have even one person, like I said, who's kind of a tiebreaker, or you have one, you have 3 of you and you have one major partner who has 50% of the vote, but the other 2. So I don't know. You got to look and see what advisors you have, how you deal with this.
Right.
At the end of the day, do you flip a coin and say, okay, fine, we know it's good or bad, and this is what we're doing? I mean, you really have to figure out a way to deal. Sometimes I don't have good answers because they don't have anybody who can be the I don't do that stuff as the lawyer. That's not, it's
right. Yeah, they have to figure out their own tiebreaker.
Yeah. Exactly.
Yeah. We talk often that there's, you're never going to get 100% consensus.
No.
That's just kind of unrealistic, but you can get agreement on how to move forward. Yeah. And it's like, okay, I don't really entirely agree with you, but we're going to give it a try.
Right.
And we're both committed to giving it a try, and we'll come back and reevaluate, in a month or 6 or whatever's appropriate for the situation. We've found that to be pretty helpful in a lot of things of like, okay, you're not, don't think this is going to work. That's duly noted, but we all come into agreement that we're going to at least give it a try for this long, kind of a thing. And that has seemed to be a good compromise in a lot of situations where we've got, team leads or managers that can't agree on how to move forward with something,
Right. Yeah.
So I thought that might work as well on a ownership level kind of.
Oh, no, there's no question about it. I mean, I negotiate a lot of things I think I'm over 33 years been able to settle most things, maybe not completely to my client satisfaction, but I think that you're right. If you have people in a room and you say to them, listen, do you think the company should never move forward? And the other person says, no, I don't think that. I just don't think this is the best way to do it. All right, then what do you suggest and what kind of compromise we can come to? Because it's not to your benefit to just both walk away from this, and sometimes maybe it is, but generally, if you want to stay in business together and you want to reap the rewards of this business, you're going to have to compromise. And then you start getting people that are saying, okay, I'm willing to see it this way if you do this. And then the person, well, if you do that, we do that. And you start getting the pieces of an agreement of some sort. Like that's the way you got to do it from a negotiating standpoint. You got to get people to move a little bit. And as they start to move, you work your way down to like where
okay, we can all agree on this part, but this part, like you said,
so let's do it. Let's start this way and do it this way. And we'll look, like you said, in 6 months, let's reevaluate. And at least you feel better about moving forward.
Yeah. Just being stuck is never a good thing for business or partnerships.
It's really bad. Yeah. And I've seen situations where partners want to break up. They have nothing in writing and, they're two young partners. And one of the partners has a father, let's say, who's got a real estate company. He's got money and he goes and bribes the landlord, or he has money to pay a lawyer and the other party doesn't have to pay a lawyer. And then you're screwed because you have no leverage. You don't have any staying power. So,
So get it in writing.
Get it in writing. Yeah.
Get it in writing. Even if it's a napkin, get it in writing.
Absolutely. Yeah. I'm also a big fan of a lot of attorneys don't agree with me, especially litigators, of arbitration. I don't litigate, so I like arbitration in a contract. Sometimes it's expensive, but it's usually quicker than going to court and you can get things moving along. But you have to have an arbitration provision in a contract to use the arbitration system, unless you agree on it at that time. But I don't know why somebody would do that. So
Yeah. No, I agree. We try to put that in most of our agreements that we're going to go to arbitration.
Just stay out of court, first. Private, that kind of stuff.
Yeah.
It's not crazy and it doesn't get really nuts. But I have a friend who's a litigant. I don't like arbitration. I don't want arbitrators making the decision that, because they want to bill. They want to charge. I understand.
Right.
That's what they do. It's like surgeons, right? I'm not saying surgeons all like to do surgery, but that's primarily what their focus is. So, they'll try and take care of you the best they can. And then they're like, listen, we've tried everything. We need to do surgery. And there's other people that would say, no, this holistic approach, you don't need to do that.
Right.
So, that's where your bent is, where your purview is. So,
yeah, for sure.
Yeah.
Well, thank you so much, Mitch. This has been incredibly informative.
I appreciate it.
Yeah, I think we've addressed a lot of things that we hear a lot from our clients and
you know what?
listeners.
I didn't tell you about my book. I'm going to make you laugh.
Oh, very good.
Yeah.
And
so it's called, you see what it says?
Yes.
10 ways to get sued by anyone and everyone. That was funny. My friend works, does like a 10 ways book series. So we came up with that title and, it's like a guide to staying out of court, all the things you should do in writing.
Nice.
And there's a lot of attorneys I've interviewed in different areas of the law that apply to different things. And it's not a story. It's a good guide to kind of have it on your shelf, but everybody laughs when I tell them the name. So
I saw that one and I love that one. If you've got a few other pieces out too, we'll make sure we get a link when we publish to all the different pieces that you've published.
Yeah.
So, and you have a podcast as well.
I do. You can see it in the background. Yeah. Mine's called The Accidental Entrepreneur. We've been I think we're a little bit more than 6 years now, 6.5 years, and 400 episodes in, and meeting people all over the world, talking about their stories, sharing, their trials and tribulations, successes, failures, advice. And I mean, that's what this is all about, right? Having good conversations,
right? Where
people can tune in, they're frustrated with business and they kind of tag on to us because somebody said, hey, Mitch and Adrienne had this podcast talking about this, and hopefully it helps some people. I mean, that was the whole goal, to kind of reach the world and help move the needle a couple of times. That's all.
Yeah. Well, I know like the financial side, the legal side, and for many of our clients, the HIPAA, PI side, those are some of the things that people, I think, small business owners lose sleep over the most. Because it's so
and they shy away from it as a result.
Right. And then, like we mentioned earlier, like dealing with it up front is uncomfortable. Dealing with it after the fact is so far beyond uncomfortable to the point of being untenable. It's like,
of course,
it's better to deal with the uncomfortable up front.
Yeah.
When it's only this uncomfortable, as opposed to, traumatic potentially later.
It's like your
on.
risk management. Like nobody wants to review their insurance policy, even though the broker's probably telling them to do it. But
Yes.
today, and I've had this with clients, that they got to work and their building had burned down because there was a fire in the kitchen and they hadn't updated their policy for years. Like they're not even close.
Right.
They had to shut down and walk away. And they didn't have money. It was gone. So those are things about, I got to spend money on that stuff. What's really a chance of if it happens and it wipes you out, then you have to address it now.
Right. Yeah.
You got to figure a way to pay for it. You got to figure a way to get the documents placed. You got to figure a way to do whatever you need to do from, financial standpoint to protect your business, even though you may be shying away from it. It's not good. It's not the way you operate. Nobody's going to treat you like, we'll give you a second shot at this. We're adults.
Right.
And you got to follow the rules. You got to know the law. You got to know the filing requirements. There's this new, I don't know if you're familiar with this. There's the Financial Crimes Division of FinCEN, federal government. There's a new filing requirement where you have to reveal your ownership information of corporations and LLCs. And if you don't do it, I don't know how they're going to enforce this, but the penalty is like $500 a day. It's ridiculous.
I was wondering how in the world they were going to do that.
I don't know. I don't know, but clients don't, know. So that's something that they now have to do. And they're not going to say, well, you didn't know.
Right. Yeah. No, I appreciate it. Our attorney's been all over it. And so, I was like, wait, when is this due? And he's like, well, it's not due to the end of the year, but we're going to take care of it now.
Yeah, it's free, one-time filing. Just do it and be done. It's part of my formation checklist. I do it. So
right. That makes
people
sense.
are like, I didn't know about that. Uncle, well, you didn't read the 7 emails that I sent you, along with probably things you got from everyone else, including your CPA, about this thing, because you don't read it. So, but that's not an excuse.
No. The do-over for small business owners is starting another business. You don't get another chance in
that's what bankruptcy
that situation.
Is called. Bankruptcy is do-over to an extent.
Exactly.
Not completely.
To an extent, right.
Yeah.
Yes.
So.
And the big guys use it intentionally as a do-over.
Yeah, of course. Like everything, people use things as a sword and a shield. Of course. That's the way it is.
Sure.
Yeah.
Well, thank you again, Mitch. And
You're
for
welcome.
our listeners, we'll make sure we've got links to Mitch's book and his podcast.
You have been listening to the Beacon Way podcast. Make sure to join us for new episodes every week. Don't forget to like, share, and subscribe to the Beacon Way on Apple Podcasts, Spotify, or wherever you listen to podcasts.